Good morning, Judge.
Good morning. Good morning. How are you?
Good.
On the Fox versus Brookfront matter.
I'm sorry, I didn't hear you.
You're on the Potts versus Riverfront matter, correct?
Yes.
All right. I'm waiting on the time and waiting on the other side. This is case number 21-161-839. This is Coleman Potts versus Riverfront Towers Apartments. Your appearance, matter, I should say, matter before set up for a pretrial conference. The court did receive an answer to the complaint in this matter. Your appearance at this time, counsel for Potts.
For the record, Your Honor, Coleman Potts, P7607 on behalf of myself today.
Good morning, Your Honor. For the record, Daniel Landman, P35797 on behalf of the defendant.
Thank you, counsel, and good morning to you as well. I do see there's been an answer filed to the complaint. So what, where are we with things? Have you all had an opportunity to talk? Do you need discovery, kind of update, you know, where things are? You first, Mr. Potts, and then I'll hear from you, counsel.
Yeah, we have not had the opportunity to talk, Your Honor. This is the first pretrial I believe we both made. I mean, I can speak to counsel now if he wants, or we'll just get a scheduling order.
All right, I'll try and set that up in a moment. Let me hear from your perspective, counsel.
Your Honor, there was another defendant in this case. The case sort of got thrown off track because there was a settlement reached between the plaintiff and that party. And unfortunately, when that party was dismissed from the case, the dismissal inadvertently dismissed all parties to the case with prejudice. So some action needed to be taken by the plaintiff to get the case reinstated as to our client. That got cleaned up. We were scheduled for a pretrial, I think, about maybe the end of January, and I think the court was unavailable. So that's what's gotten us to this point. Our position is that pursuant to Redmond versus Leet, the plaintiff's cause of action is legally wanting.
All right. Here's what I want you to do. I will certainly set up a schedule on this matter. I'm thinking maybe 60 days. Do you think it will be beneficial for the parties to speak in a breakout room on this matter to see if there's any particularly forward?
I'm sorry, Your Honor, I didn't hear you.
Yeah, I'm asking whether or not it would be fruitful for the respective attorneys to talk in the breakout room regarding the issues in this case. Mr. Landon, what do you think, sir?
Your Honor, I have no objection to speaking with Mr. Potts.
Sure, we can talk.
Let's take a moment to do that. Then you come back in. Let's see how far you got, and if anywhere, and then the court will set up a schedule, make sure this case is moving forward. So you're receiving a notification from me now that gives you access to the breakout. And there you are, gentlemen. I'll speak with you shortly. Good morning, Ms. Francis. Which matter are you on, ma'am?
Good morning, Your Honor. I am here for portfolio recovery 19167296.
All right, so it's set for 10 a.m. So I'll be calling that
Yes.
short. Thank you.
Okay, thank you, Judge.
Mr. Looks like I see a Mr. Kenneth Tenzel. Good morning to you, sir.
Good morning.
All right, what are you here on, sir?
Last three numbers are 337.
Sorry, it's set to 10:15. We will be getting to that matter. Mr. Barris, good morning to you, sir. Which matter are you on, sir?
Good morning, Your Honor. Here for plaintiff on 337, Citibank versus Williams.
Do I have Mr. Williams here?
I'm here for plaintiff Citibank.
Mr. Counsel, what last three digits did you say you were on, sir? Mr. Tanzo? All right, this is case number 21-171-887. This is M&M Jonathan Investments LLC versus Rachel Williamson. The matter is before the court, set on for looks like a pretrial hearing date. It's like a status hearing date where the matter has been recently transferred to this court by virtue of an order changing venue. For the plaintiff in this matter, please. For M&M Investment, if you on this zone, or defendant, please.
Your Honor, Michael Cafferty on behalf of plaintiff M&M Jonathan Investments.
All right, thank you. Thank you, counsel, and good morning to you, sir.
Good morning to you, Judge.
Give us your P number, if you will, for the record, sir.
Your Honor, the P number is 36613.
All right, thank you, counsel. All right, do I have someone here for Rachel Williamson? Rachel Williamson, you here, please say something at this time. Looking for Rachel Williamson. All right, the record should reflect that the court did provide a notification with regard to the hearing date, directing that notification to Rachel Williamson on Press Street in the city of Detroit with this date and time set as a hearing date regarding this matter. Counsel, have you had any occasion to speak with Ms. Williamson or any contact with the defendant in regard to this case since being transferred?
No, Your Honor, I have not. And just a little bit of background on this matter. Before it was transferred, and I think what probably caused the other court to transfer the case is I had filed a request for a default judgment. And rather than enter the request for a default judgment, the other court opted to transfer the case here. So I'm not sure that Ms. Rachel Williamson is that interested in defending this case. She's never responded to anything in the case.
Yeah, and in noting the, looking at the proof of service in this matter, although it was in another court, it looks like that proof of service was personal service to her back in August of 2021. And you're indicating in the file seems to support the fact that she did not respond during those proceedings. Is that correct, counsel?
Yes, Your Honor. And I would add there's a co-defendant and the co-defendant was never served. That's Gloria Williamson. So she's no longer in the case. It's only Rachel Williamson.
Thank you, sir. Given the circumstances that set forth notification that has been previously given, on that notification provided the defendant's failure to appear would in fact result in the court entering an order of default. The court will enter, the court will find the defendant is now in default in this matter, and the court will enter a judgment consistent with the complaint and the prayer for relief in this matter upon presentment to the court. So, counsel, you can present your judgment. The court will sign the same. You can send that in fact by email. I'm going to give you the email address that you can send that to, so we can get that right back to you. That's
Thank you.
LATIFA.Hunter. That's at 36districtcourt.org at 36th.org.
I'm sorry, Your Honor, could you give me the first part of that again?
Yes, that's Latifah, Latifah .Hunter at 36districtcourt.org.
Thank you very much, Your Honor. I will get that submitted.
Thank you, counsel, and good day to you.
Same to you, Your Honor.
Do I have Tracy McLemore on this Zoom? Tracy McLemore, if you're on this Zoom, say something. Do I have Anthony Williams on the Zoom? If you're on the Zoom, say something, Mr. Williams. Anthony Williams.
Yes, I'm here.
All right, this is case number 21-166-337. This is City Bank versus Anthony Williams. The matter is before the court on the filing of a general civil complaint in this matter. The court did receive the filing of an answer to the complaint regarding this matter. Your appearance for the plaintiff, counsel.
Morning, Your Honor. Jeffrey Beers, P 41693, on behalf of plaintiff Citibank.
All right, thank you, Mr. Beers, and good morning to you. Good morning to you, Mr. Williams. It looks like good morning again. It looks like in this matter addresses a claim that a certain account that was held, that payments were not fully made on the account. As a result of that, a complaint was brought relative to a breach of contract with the allegations that the principal amount that's owed is $3,217.36. All right, so have parties talked about this at all before today's date, Mr. Bears?
We have not, but we can go in a breakout room if you like.
Yeah, that might be a good starting place, Mr. Williams, to talk about it and see if their parties can find a way to come together on this. I will be here, come back in, see if we can get this worked out. If not, come back in and the court will set a schedule on the case to try to get things moving forward. So I'm going to give you a notification, Mr. Barris and Mr. Williams. I'm going to get a notification to go to a breakout room. And let's see, I got Mr. So let me just adjust this. Williams, I've sent you to appropriate breakout room, and Mr. Barris is going to be there.
Okay, just press the join.
Yes, sir.
Okay. All right, the court calls case number
12-122-939. This is MCR DFA 1 LLC versus Earl Gray. Matters before the court on the following objections to a writ of garnishment. The writ of garnishment arises by virtue of a judgment that was entered in this matter on May the 14th, it looks like 2013. That judgment was for $1,030.15. Your appearance for the plaintiff in this matter, please. Looking for the plaintiff in this matter. Do I have Earl Gray in this matter? Mr. Gray, you're here. Please say something.
Yes, Your Honor, I'm here.
All
Earl
right,
Gray.
thank you, Mr. Gray. All right, just one moment, sir. Anyone from the law firm of Katz and Associates? Katz and Associates present at this time. All right, Mr. Gray, this garnishment is directed against, it looks like your employer. Is that you work for Delta Airlines?
Yes, sir.
All right, so you understand the reason that this garnishment is coming your way is because of the outstanding balance on that judgment that was entered back in 2013. It looks like in 2016 there was a garnishment against your income tax return. They were able to gain, it looks like some $266. So their balance seemed to have gone down to $900 as of that time. But with interest and et cetera, who knows where it may be at this time. So tell me why you believe that the garnishment should not be effective against you, sir.
Well, one, I never received any documents on this whatsoever at this point. And when I did, the only documents I received was from Delta saying that it was garnishment. Up until then, I didn't even know about that. That's who took the taxes out for that year. As soon as I did find out through Delta, though, I contacted them through email and sent them a letter. I didn't hear any response. I just got an email back saying that they couldn't tell who they weren't going to open any documents or attachments because they couldn't tell who the letter was from. But in the letterhead, you know, I had my case number, the file number, and my name. So I don't know what more they needed from that, and I haven't heard back since I found out about this case from them. At this point, from what they've taken out of my check, at this point, it's pretty much paid in full. I don't even know who the case is from. I still don't have any information on who I'm even paying back at this point.
Okay. So let me try and look at some of that and see where this arises from. Although the law doesn't allow me to get into those because this is posted. Let me see if I have anybody from the Katz law firm here at this time. Anyone from the Katz law firm? All right, just one moment, Mr. Craig. All right, this the company that sued you indicated that you were indebted at that time for $842.15 for items charged on the defendant's account. That was back in 2012 when this was filed, and then there was an affidavit attached regarding that account. Still looking, and what happened is. The plaintiff bought this debt from Sterling Jewelers, and once they purchased the debt from Sterling Jewelers, then they sued you. So it sounds like this has something to do with some jury or something back in 2012. That's where it comes from. Let me ask you, how much money has been taken from you?
At this point, I believe it's around almost $700, like around $700 to $800, I believe.
Okay, and that's just the garnishment from with Delta?
Correct, yes, sir.
All right. So you get paid every other week. Is that how it goes with this?
Yes.
All right, and how much do they take? I mean, I'm sure it's not the same amount, but roughly, what do they take every 2 weeks?
They're taking 25% of my check every 2 weeks, so it's like around 353.
Okay, so now you know I already knew about that 25%. I just wanted to know the dollar amount. All right, so about 350 is what you're saying. And how many times has your wage been hit? Twice?
It's been hit twice. Yeah, on this Friday it'll be a third time.
The third time. All right, so I've looked at this in the garnishment that you filed. The objections really are not a valid objection to this matter. If you're going to attack the underlying case, you would have to file something like a motion to set aside a default. But you did raise the correct issue, and that is that it looks like one way or the other, you should be close to being done with this. So what I'm going to do is I will find that the objections are invalid. I'll release any funds held to the plaintiff. I'm going to stop that garnishment after this Friday. I'm going to give you an order that says that after this Friday, the garnishment is stopped and they can no longer take the actions against you. You understand?
Yes, sir.
All right, now, if you believe that there's a basis for the judgment to be set aside, you still can file something in an effort to do that. And if you're successful in that regard, any money taken from you would have to be refunded. You understand?
Yes, sir.
All right. So I'm gonna stop that. I'm signing an order now to stop the garnishment. Yeah, they may very well get that last payment, but that should satisfy it anyway. But it will definitely be stopped after that, so no more money can be taken from you. Understand?
Yes, sir.
All right. I wish you well, Mr. Gray, and you'll get the orders from me in the mail, sir. Good day to you, and I wish you well.
Thank you as well.
Welcome back, Mr. Potts and Mr. Landman. Gentlemen, I know that you've taken a moment to speak in the breakout room. I'm on the suffix 839. Any updates that you wish to bring to my attention at this time? Mr. Potts, please.
We'll just get a scheduling order, Your Honor, some time for discovery and see if we can work this out in the meantime.
All right. Sounds like it makes sense to you, Mr. Landman, sir.
Yes, Your Honor. We were not able to get the case resolved. I did appreciate the opportunity to speak with Mr. Potts. However, one of the things that I think Zoom deprives us of is the opportunity to interact with opposing counsel and get to know them. And it gave me the opportunity to learn a little bit about Mr. Potts and his practice, and it's information that could very well come to be of value down the road.
And one of the greatest downsides to this is I don't get to do as much arm twisting as I might usually do. I'm being facetious. Anyway, I'm gonna set the matter up on a 60-day discovery process. I'm gonna have you return to
May 26th.
On May 26th, 5/26, and that's gonna be at 9:45 a.m. 5/26 at 9:45 a.m. An interim discovery will be open through that period of time, and so of course you can exercise all of the devices that are available to you to try and narrow issues in this case. Moreover, the court is going to allow you to file motions and set them for hearing on that return date. That return date again is the 26th of May at 9:45 a.m. Any motion set for hearing on that date, I will hear the motion, so long as you allow the other party to have at least 10 days to the motion. So long as you file your motion, even if it's a dispositive motion or non-dispositive, as long as you allow a 10-day leeway for the other party to respond to the motion, I will hear it. This may shorten the time that would normally be allowed under court orders. It is shortened by this court's order that allows you to file motions for summary disposition or otherwise, and allow a 10-day period for the opposing party to respond. And if you do it that way, I will hear the motion on the 26th of May. This does not preclude you from filing motions in the future, but it is a tool of efficiency that if you find that there's a basis where you present your motion, you do not have to search for another date. You already have the 26th upon which the motion will be heard. You'll get in writing from me a document, a scheduling order that will set forth the information that I've set on this record. And I look forward to seeing the two of you on the 26th of May at 9:45 a.m. Good day to both of you.
Thank you, Judge. Have a good one.
Thank you, Your Honor. Thank you, Mr. Potts.
Thank you, Mr. Lamb. Nice to meet you.
Absolutely.
I see that Mr. Barris and Mr. Williams is back, and that is the subject 337. Thank you for taking the time to discuss the matter. Mr. Barris, if you'll update me on things, sir.
Yes, Your Honor, you had an opportunity to speak with Mr. Williams, and it was productive. He's really not contesting the judgment that's already entered against him. Just wants to work out payments. There were offers and counteroffers going back and forth. He has a debt settlement company. We work with debt settlement companies. We were not able to come to a precise settlement this morning. However, we exchanged the email and phone numbers. We're going to continue talking after today. There is currently a default judgment entered by the court that has not been set aside yet. So we would ask that that be that remain undisturbed, and we'll continue to work out installment payments.
All right, now I am not seeing I'm not seeing a default judgment in my file. Let me see if I can get a register of action to see where that's going. You ready now?
Yes.
Well, Your Honor,
37. Just one moment. Just one moment, Mr. Williams.
okay.
All right, I'm looking at the register of action. I do see the entry of a default judgment on the 2nd of November of 2021. I see that the defendant's answer was sent to the file for review on October the 22nd, 2021. So it looks like there was an answer filed, and before the court got to look at it, the default judgment was entered. So that probably that's probably a bit problematic if that schedule is correct. So, but let me, Mr. Williams, you indicated that your big issue here is that you want to figure out a way to get on some type of payment plan to start paying on this. Is that what it is?
Yeah, yes. Just like I was telling him, I'm not trying to. I want to go ahead and get it settled for us, the payment and stuff. But like I said, we were in the process prior before we came to the court. My debt consolidation group was talking to them the other day about selling this plan, but they had put a garnishment from what I was heard that against it. But we was like, well, how could we put a garnishment when we already had a trial date set for today?
All right. So
yeah, before.
I'm listening to you. Go ahead.
Okay. Yeah, no. Because before we got here, it actually was Monday. We were we're trying to make a plan to settle it for us, making a plan of making a $2,400 settlement for 24 months. I mean, for 12 months.
Let me stop you now. But I can't let you get into those details.
Okay.
Okay. Get it out. Mr. Barris, it sounds like to me that the judgment and any garnishment should be set aside in this case. It further sounds to me like there's not really a dispute regarding the entry of a consent order of judgment by the parties. Mr. Williams says that there was some discussion about allowing him to pay a certain amount over a period of time, and if he paid that amount, then the judgment would, in the end, the balance would be suspended. If he did not pay that amount as directed, then if he defaulted, the entire balance would be covered. That sounds like something he said that was being talked about. So I think that that default has to be set aside because it seems like there was an order that was in place. But
That's
it
fine.
seems like are not far from being able to reach a consent in this matter that will direct the case forward. So I'll go ahead and set the default aside. If you wanted, I know you spent some time, and I appreciate it, but if you wanted to go back to the breakout room for a moment to see if you could work on that in consent order, that might be a good way to do it, so that both parties take advantage of the opportunity to try to resolve the consent way to go forward. And if it's some of what Mr. Williams was talking about, then it would mean, Mr. Williams, that if you follow the plan, you may in the end have a reduction, but if you default on the plan, it falls back to the full amount. So I'm going to send you all back to the breakout just to kind of work through those logistics. And if we can't get it worked out today, I'll set another date. But it seems like you're not as far apart as maybe the circumstances would suggest. So I'm going to send you to one, and you have priority treatment. You come back in, I'll get right back to you. Okay, so we're not wasting time.
Okay, thank you.
Okay.
And I'll talk to you shortly. All right, this is case number 19-1672-96. This is portfolio recovery versus Tracy McLemore. Matter is before the court on objections to a writ of garnishment. The record should reflect in this matter that a judgment was entered in this case on the 24th of January 2020 for the total amount of $1,911.19. This is an objection that seems to relate to the state income tax, Michigan Department of Treasury. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Sandra Francis on behalf of the plaintiff, P74229.
All right, thank you, Ms. Francis, and good morning to you. Let me see if I have the other side here. I am looking for Tracy McLemore. Please say something here, Ms. McLemore. Tracy McLemore. I note also that the defendant did file a petition for partial payments regarding this matter, and it looks like on that application she is estimating that she owes some $1,768, and she wants to pay $50 per month. The objections do not list a basis for filing the objection. Madam Counsel, I don't see the other side here. What do you have to add or anything to say regarding this matter?
Your Honor, I would ask that both the objection to the state income tax as well as the request for payments be denied at this point in time. As far as the objections to garnishment, as the court indicated, there is no valid legal objection stated, and the defendant has failed to appear today. So I would ask that both the motion and objections be denied.
All right, with regard to the objections to the writ of garnishment, effectively, there are no objections. Nothing has been noted on the form. So the court will at this time, particularly given the fact that the defendant has not even appeared to give me some sense of what she might have meant, I will deny the objections and find that they are invalid at this time. I am signing the order to that effect to release any funds that were held to the claimant. With regard to the application for partial payments, the defendant has indicated her average weekly income. She's noted some expenses, etc. And she's asked that she be allowed to make payments at $50 per month. As I looked at the application, I'm going to grant her application with modification, make a partial payment. I will set the payment in this matter at $80 monthly. And I'll allow the commencement of that payment, of the first payment to take place on or before the 15th of April, 4/15, 22, and continue thereafter until the balance has been satisfied. The court's going to allow the partial payment, and also allowing the non-periodic garnishment as it relates to the state income tax return. So that will be the order. Those will be the orders in the mail right away.
Your Honor, in the event of default, may we file an affidavit of non-compliance?
But what happens is that you simply will file and set it aside.
A motion to set aside. Okay, that's fine. Okay, thank you, Judge.
All right. Thank you, Counsel.
Thank you. Have a good day.
The court is calling, welcome back, Mr. Barris and Mr. Williams regarding the Suffolk 337. Welcome back, Mr. Barris. What's the status of things at this point, sir?
Your Honor, we spoke again. I'm sorry we just can't get it done today, but we're going to keep on trying. I'm optimistic. So maybe if you wanted to, Your Honor, we could do a pre-trial today and get some dates.
All right, very well. So what I'm going to do, I want to bring this back sooner rather than later. And so I'm going to go ahead and, Counsel, do you need anything by way of discovery in this matter?
Yes, can we have 60 days, Your Honor?
All right, so I'll go ahead and send it over for 60 days. That gives both sides the opportunity to ask questions, to submit documents, submit documents requesting information disseminated over that period of time. Can do the same. So I'm going to set this to come back on 4/7.
May 26th, 60 days.
Thank you. Where are you for? May 26th, my clerk says, May 26th, 2022. And that's going to be at 10 o'clock a.m. In the interim, the parties may utilize the vehicles of discovery through the 26th. The parties also have the right to file any motion that they wish to file in front of this court and set a motion on for hearing on that same day by 26/22 at 10 o'clock a.m. The only requirement is that you give the other side at least 10 days to respond to your motion. It could be a motion that's dispositive or non-dispositive. As long as you give the other side 10 days notice before the hearing date, the court will hear the motion on the 26th of May 2022. All right, you'll get an order in the mail from me with that same information on it. And I look forward to seeing two of you at the next hearing. Hopefully you get it worked out in the interim. If not, the court will be here to assist in that. Good day to you, Mr. Williams. Good day to you, Counsel.
Thank you. Your Honor. Have a good day.
Yeah, have a good day.
All right, the court now calls case number 18-148-970. This is J.J. Marshall's Holding versus Asia Rail. The matter is before the court on the filing of objections to a writ of garnishment. The court also notes that the judgment in this matter was entered by default on the 21st of August of 2018. The total judgment amount on entry was $2,219.23. Your appearance for J.J. Marshall's Holdings, please.
Good morning, Your Honor. Dylan White, P80755, on behalf of Vela Law Office for J.J. Marshall.
Thank you, Mr. White. Good morning to you. Do I have Asia Harrell on this Zoom? If you're here, please say something at this time. I'm looking for Asia Harrell, living on Moneta Street in the city of Detroit. If you're on the Zoom, please say something. All right, this is an objection to the Michigan Department of Treasury. The balance on objection remains outstanding. I looked at the objection that was filed as a supplement to the form. It indicated the defendant cannot afford to have taxes, wages, and or bank account garnished. That is not a valid reason or a valid objection to a garnishment. For that reason, I would have to find that the objections are invalid, that any funds that are withheld will be released to the plaintiff. If you unmute again, allowing noise into my hearing, I'm going to have to dismiss you. So that is my order in this matter. You get an order denying the objections to the garnishment. Thank you, counsel.
Thank you, Your Honor.
The court now calls case number 2146674. This is Munich Insurance Company versus Beverly Denise Moore. The matter is before the court. It looks like on the filing of objection to a writ of garnishment.
I'm here.
Yeah, just a moment. Let me have the plaintiff for Munich Insurance, your appearance at this time.
Yeah, good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
All right, thank you, counsel. And it sounds like I have Miss Beverly Moore here. If you're here, say something, ma'am.
Yes,
All right, what is your name?
Beverly Moore.
All right, thank you, Ms. Moore. All right, this matter is before the court on objections. It appears to a writ of garnishment. This case arises by virtue of a judgment that was entered on the looks like the 17th of September 2020. That judgment was entered by default for the total amount of $12,292.58. Looks like there was a previous writ of garnishment and then a more recent writ of garnishment that has been filed in objections to the same. Looks like that application for garnishment relates to the Michigan income tax, Michigan Department of Treasury. I don't have all of the paperwork that I would normally have with this. So tell me, counsel, the writ of garnishment, is that the state income tax writ of garnishment, sir?
Yeah, Judge, I reviewed the ROA on this file and I was puzzled in that the court seems to have already denied these objections on March the 16th. And I don't see that the court ever noticed up a hearing for what it decided on March the 16th. And so it is for a tax garnishment, but I was a bit confused. We received an order from this court denying the objections on the 16th, but I suspect nobody appeared on that date.
I am as unclewed as you are on this, but it does look like some action was taken on the 16th, and that would have been last Wednesday. So apparently, this matter was up at that time because that's when I hear these is on Wednesday. So I have no idea what happened. Were you here last Wednesday?
I was not, Your Honor, and we didn't receive any notice to appear last Wednesday. And the Register of Actions doesn't really indicate any type of notice was sent to appear last Wednesday. The Register of Actions does direct the parties to appear here today. So I think that may have been done in error. And perhaps we just proceed today with the objections as if that order wasn't entered, but something needs probably to be done with that.
I got you. Ms. Moore, were you here last week on the 16th?
Yes, sir. Yes, Your Honor.
Oh, okay.
Oh, well,
So
stand corrected.
No, you.
at that time on the 16th, what I did is I denied the objections to the
Oh.
writ of garnishment.
Oh, what, yeah, I had a court date. I'm sorry. I was there to see Miss, Judge.
Stop you. Okay. My specific question to you is last Wednesday, March the 16th. Did you?
I'm trying to, I know I was in court on the 20, I'm trying to read it, Your Honor.
Did you see me last week?
I was there on the 23rd, Your Honor.
Did you
I
see
don't
me
know.
last- Oh, no, you couldn't forget if you saw a handsome man like me last week. So apparently.
You are,
I'm kidding.
Your Honor, you are the judge I've seen. But, yeah, were the judge I've seen, and I didn't even know what this was pertaining to until now.
Okay, all right. So it looks, I have no clue, but apparently what the order of the court did was it denied the objections. Immediately released all funds withheld to the plaintiff.
I'm sorry.
So any funds that were held are being held by the Michigan Department of Treasury. The court issued an order releasing those funds to the plaintiff. So this case has to do with a judgment that was entered against you back in 2020. The plaintiff filed to garnish anything that you might be receiving from your state income tax return. They filed asking the court to allow that to come to them if you got anything back from your state income tax return. And I determined that that given the fact that there is a balance on this judgment, that they would be entitled to recover whatever money might come through income tax return. That is the state income tax. They can't garnish the federal. You understand that?
I understand what you're saying, but I don't understand. I didn't do anything wrong. I don't know what it's pertaining to or how this is happening. I never received no letters or anything written or until I went to get my license renewed. Is when I just found out about all of this. And as soon as I found out, I acted immediately to see what's going on.
I believe I remember speaking with you now because it seems to me that what was brought to your attention about this is that the insurance company filed a subrogation claim because they paid out benefits to someone because your vehicle was involved in an automobile accident, and when they paid out those benefits to another party, they were entitled by law to come after you to recover what they paid out. That's what the nature of this case is about. Now, if you believe that that case should have never been filed against you, you have to go back and file some type of motion asking for the default judgment to be set aside, because that's what happened. You have a judgment against you now.
Yeah.
One part of this is pre-judgment. The second part is post-judgment. The reason we're here today is regarding post-judgment. That means that there's a judgment already in place, and the plaintiff has the right to collect on that. Now, if you go back and file something indicating that you didn't receive notice or indicating some reason why the judgment should be set aside, if that judgment is set aside, any money collected from you would have to be refunded to you. But in the meantime, because there is a judgment in place, the plaintiff has the right to collect on that judgment. It seems like your attack is that you didn't receive notice of the complaint, you never knew about this case, you never knew anything about a lawsuit being filed against you. You would have to get the information on this file, the case number and everything, and then file your motion, your petition, asking the court to take action to set it aside because you believe that you have good cause for not responding to the complaint, and that you have a meritorious defense, or simply that you never received notice required by law in this matter. That's what you'd have to do. That's not by way of legal advice. That's simply information. You'd have to approach the case in that way. So the objections, as I previously ordered, under whatever the circumstances were, the objections to the garnishment are denied, and any funds released, any funds held by the Michigan Department of Treasury would have to be released to the plaintiff. That is my ordinance.
Oh, Your Honor,
Yes.
I don't have an attorney. I can't afford an attorney. I tried legal aid. I can't get no response from them. This is all not true and wrong. I never injured anyone. I never got a police report. I never gotten anything. I'm just learning of all of this, and I can't drive, and I just don't understand.
Your
Why?
Honor, I'd be happy to speak to her in a breakout room after conclusion of these proceedings. I did solve the mystery of why the matter was set for last week. The actual objection to garnishment that the defendant filed, handwritten on that motion, was last week at this time. And then someone took a line and drew a line through it, presumably the court, crossed that off, and then issued a new notice for today. But apparently that prior notice remained on the court schedule, or at least the defendant appeared. And I think that's why it got heard and why we didn't appear, because we disregarded that and appeared here today. That being said, Judge, I'm happy to speak to Ms. Moore in a breakout room, maybe walk her through how we got here and see what we might do going forward.
Yeah, I think so. And obviously, one of the things that is her concern is the prospect of getting the lien on her license set aside. And
Yep.
So the parties can talk about any number of things. So I'm going to go ahead and give you notification in that regard. And so, ma'am, when you receive the notification, just click into the breakout room. There's your notification. And Mr. Cox, I'm sending the same to you. You go into breakout room number 1.
Very good. Thank you, Your Honor.
Shows on the register of action.
She must have been here.
But I don't have the paperwork.
Oh, yeah, there's paperwork. We didn't have, the paperwork was sent to the file on the 16th. So it's downstairs.
So I wouldn't something mail out.
Yeah, I would have mailed it out on the 16th.
Thank you all for your patience. This is case number 18-150-803. This is Credit Acceptance Corporation versus Tamika King. The matter is before the court on the following objections to a writ of garnishment. The defendant also has filed a petition, it seems, for installment payments. Your appearance for credit acceptance, please.
Judge, may I please court, Attorney Richard Bruson, my bar number 35222. I am the attorney for credit acceptance, and I'm the respondent to defendant's petition.
Thank you, counsel. Good morning to you, sir. I am looking now for Tamika King. Ms. King, if you're on the Zoom or someone representing Ms. King, if you're on the Zoom, please say something at this time. All right, the record should reflect that the matter is set on for 10 o'clock again. It's now 10:40. The court did direct notice to the defendant at the address provided by the defendant on the Costa Street. And that notice would have given her the opportunity to be heard on this matter today. Counsel, have you had occasion to speak with Ms. King prior to this hearing today or anything, sir?
Well, Judge, in this case here, the defendant did contact my office. I can tell you that I signed a letter to Ms. King March 11th that will settle the case in whole, but the settlement payment's not due until June 8th, which is considerable, but it's more than 90 days away now. So I did not tell her not to show up. I know that's a double negative. So I asked for a couple of things. As the case continues, and hopefully we can resolve it, I would ask today that you deny the defendant's objection to the income tax garnishment, but I will stipulate to an installment payment order, $55 per month. I don't have a copy of the installment order petition with me to review, but I would gently suggest that if it would start up maybe 30 days from now, which would be on or about April the 22nd, that's a Friday. I think that'll be productive, and if we can get the case settled, well, then I'll follow the appropriate satisfaction of judgment at that time.
Got it. And thank you for bringing that information to the court, sir. Appreciate it. I will go ahead and I think the only thing the court could do reasonably is to deny the objections to the writ of garnishment. The defendant noted on the objection that she made payment arrangements. Such payment arrangements would not prevent the non-periodic garnishments such as the state income tax intercept. So I'll deny the objections with respect to that item. In regard to the installment petition for installment payments, the petition set forth a request for payments at $15 per month on a $3,800 judgment amount, or $3,600, whatever the amount would be at that range. That amount would seem to be unreasonable. So I will, as a reasonable request, is the amount that is in the nature of $55, as counsel has requested. Again, we're operating without defendant here. It does not seem to be an unreasonable request. So I will set the amount at $55 per month. I'll have it commence on April 29th. Counsel did bring to my attention that there was some payment plan that may be reached that affects the month of June. And I'm sure that that where that may be the case, that all of these things will come together and resolve the case. In any event, I'm setting it at $55 a month, missing on the 29th of April 2022. And those will be the orders issued by the court today.
All right, thank you, Judge.
Thank you. Good day to you, sir. The court now calls case number 21-14669-0. This is Midland Credit Management versus Willie Rawls, RYALS. Management for the court on the following of objections to a writ of garnishment. This is in relationship to a judgment that was entered on the 29th of
Good morning, Judge Perry, P6940 on behalf of plaintiffs.
All right, thank you, counsel. Good morning to you. I'm looking now for Mr. Willie Rawls. Please say something if you're on this Zoom, sir. Mr. Rawls, if you're there, sir. There's somebody that has a loud noise in their background, and that's why I keep muting them. Mr. Rawls, if you're there, say something, sir.
Hi, Miles here.
Are you Willie Rawls?
Riles.
Riles. All right. Thank you, Mr. Riles. Good morning to you, sir. This is objection, looks like, against your wages at All Pro Color. Is that correct, sir?
Yes.
All right. You indicated you filed objections to the writ of garnishment, and you indicate your reason your father with the same name and address was issued all paperwork, and he suffered from dementia. So it sounds like to me that you are attacking the underlying judgment, and if you're going to do that, you have to file a different type of proceeding or a different type of action. That's not an appropriate objection, really, to a writ of garnishment. But let me hear from plaintiff in this matter.
Judge, I would agree with the court. The only issue today is whether there's a valid basis to object to the garnishment under MCR .3101, paragraph K. You can't attack the underlying judgment in a garnishment hearing. I'm asking the court to deny the objection and allow the garn to continue.
Yeah, you may have something to work with, but you can't do it in this setting, Mr. Riles. The law requires that if you believe that the judgment is improper, you have to file an action against the judgment. This is an action post-judgment. This is an action that relates to the garnishment. The judgment in this matter is $2,395.71. Let me ask you, Mr. Riles, how much money is being taken from you on each pay period, sir?
$300, right around 300.
Okay, and you get paid twice a month?
Yes.
So how many times have you been garnished, sir?
One time so far.
All right. And so when is your next payday?
Next week.
Okay, gotcha. All right, sir. So your objections, you don't have a valid objection to the writ of garnishment, and so I will deny the objections and release any funds withheld to the plaintiff. It sounds like you might be in a circumstance where you may be able to make partial payments. If I was to allow you to make partial payments, sir, how much do you believe that you could pay a month, sir?
Your Honor, I have no objection to paying the money, but what happened, I was with Midland Credit. We made an agreement for $800 when, as things were going, COVID hit, and I stopped hearing from Midland. And then I got the letter saying that I was being garnished for $2,000. I made an agreement to pay $800 with Midland Credit.
All right. But you never made,
that would have. No, I never made the. No, because they were sending me something via email and I never received it. And I was talking back and forth with Midland Credit, but I think it was a breakdown of communication because they're somewhere in India or something, and I couldn't understand them half the time, and they couldn't understand me. But I know they agreed to $800, and if they'll take the $800, they got $3, and I can always give them the $5 now. $2,000 is more than the original amount I borrowed.
all right, sir. I'm looking at some of the documents of the bills and stuff that was sent, just making sure it's electronics. And I see billings at $1,800. See, I see a bill for $2,279. So you might have had an agreement to compromise it at some point, but it looks like to me that we didn't. That agreement was never consummated by anything that was signed off on by both sides. Let me hear from counsel on this matter, sir.
Yeah, Judge, the position is the same. If he didn't make the payment, then there's no consummation of the agreement. The judgment was properly entered. There is money due and owing on the judgment. At this time, we're seeking payment in full.
All right. So, sir, you got to deal with the judgment. You can file a motion if you want to try and get that set aside or to raise reasons why you believe that the judgment should be different or something along those lines. Right now, that's the situation.
Hey, 300 is crazy. Right now, $50 every pay period is about what I can afford without, putting myself in harm's way.
All right, thank you, sir. All right, so first thing I'm going to do is I'll deny the objections to the writ of garnishment for the reasons that I've set forth on this record. Any funds that are withheld so far, I will release those funds to the plaintiff. Regarding going forward, I will give you the benefit at this point of stopping the garnishment. Excuse me one second. I will stop the garnishment. I will require a payment at $200 per month, sir. Now, again, if you're able to get this set aside, then you would be entitled to have your money refunded to you. You would also be entitled to stop the proceedings that are against you if you're able to get that set aside. But I will, in exchange for stopping the garnishment, I will set a payment order in place at $200 per month. I'll allow for the commencement of that payment order on the 8th of April 8th, 2022, and continuing thereafter until the balance is satisfied. Again, you could still call their office or speak with Mr. Perry's office and see if they are willing to compromise on the judgment. See if they're willing, if you're able to make a lump sum, things like that. You can always talk with somebody to see if you can get to that kind of resolution. I regret, of course, that the earlier resolution didn't work out. Those kind of things are not enforceable unless both parties have signed off on it. And that didn't happen in this case. All right, so that's my order. You got to start making the payments at $200 per month, starting on April 8th. I'm stopping the garnishment so that you can do it that way, or that when I say stop the garnishment, that's suspending it, meaning that if you miss the monthly payment, the garnishment can be reinstated. It's not dismissed, it's just suspended in light of payments. Right?
So who am I making the payment to?
All right, I'm going to put you in a breakout room to talk with Mr. Perry.
So real quick, Judge, pardon my interruption. I have no
information regarding how to go about making payments. You may proceed at this time, Mr. Perry.
Yeah, pardon my interruption again, Judge. I have no objection to the entry of the payment order of $200 a month, though. May I suggest that we start the payment plan a little later in the month of April? So in my experience in recent times, that sometimes it takes the employers a pay period or two to stop the garnishment. And I would hate for Mr. Riles to be garnished and be ordered to make payments simultaneously. So maybe we can start at the end of April.
All right, let's do that. Let's put it for 4/29, and we're going to try to get the order out right away. However, for stopping the garnishment, but if he happens to get garnished anywhere in the interim, that will take into consideration the fact that occurred. All right, so April 29th, payments commence at $200 a month, and I'm putting the two of you in a breakout room just to go over logistics in terms of where payments are made and things along those lines. All right. So you receive notification from me now. There you are. All right, this is case number 153-732. This is Discover Bank versus Elisha Iverson. Matters before the court on the filing of objections to a writ of garnishment. This is in regard to a judgment that was entered in this case. Looks like that judgment was entered on. I don't have that register of action.
Your Honor, should I place my appearance in the record?
Your appearance for the plaintiff appeal.
William Saloon, P41487, Perry, on behalf of plaintiff Discover Bank. Judge, I think this is a motion for entry of default judgment. Fine.
Let me look a little closer. All right, thank you, counsel. I wonder I can't find certain items and documents and so on and so forth. All right, thank you, sir. Do I have on this Zoom Iverson, last name Iverson? Anybody representing Iverson living on Chalmers Street? If you're on this Zoom, please say something at this time. This matter set on for hearing on a petition for entry of default judgment, default of defendant was previously entered. This hearing is simply to determine whether or not the judgment itself should enter. The defendant was provided notice of today's hearing by way of the court's notice of hearing, and it was sent to the address of Chalmers, and directing the defendant to be here today, or that a judgment will enter. Counsel, defendant has not appeared. Your desire at this time, sir.
Your Honor, I would ask the court to enter a judgment by default. Does the court have a judgment in the file?
I do, sir. The court will enter the judgment now by default for the reasons set forth on this record. And the judgment will enter for the amount paid. The total amount is $7,629.23. It is so ordered at this time.
Thank you, Your Honor.
Thank you, counsel. Good day to you, sir.
Have a good day, Judge.
All right, this is case number 21-155-417. This is Jefferson Capital Systems versus Elizabeth Miller. The matter is before the court on the filing of a motion for summary disposition. The court also set the matter on for trial. There's been a request that the trial date be set over, that the court will address the motion in this matter. Your appearance for the plaintiff.
Good morning, Your Honor. Michael Bengstein, P 69778 on behalf of Jefferson Capital Systems LLC.
All right, thank you, counsel, and good morning to you, sir.
Good morning.
I'm looking now for Elizabeth Miller or someone representing Ms. Miller. If you're on the Zoom, please say something at this time. All right, looking again for Elizabeth Miller, a person living on Hereford Street, 6135 Hereford, in the city of Detroit. It looks like the court did direct this notice to the defendant regarding today's court date, and with the correct Zoom number. It appears that the defendant has not appeared at this time. Counsel.
Thank you, Your Honor. We have not received a response from defendant on our motion for summary disposition. The defendant's not here today. A validation notice was mailed to her in May of 2020. The validation notice was not returned or disputed. And in fact, the following month on June 2nd, the defendant did speak with our office. She stated that she received our validation notice, but that she was off work due to COVID and was unable to pay. She said nothing at all about disputing the debt. So in fact, she's acknowledged that she received the validation notice. Defendant opened the account, used the utility services, made payments on that account. The last payment I'm seeing is $88 on April 6, 2015, as demonstrated by Exhibit A to our motion for summary disposition. Defendant received monthly statements, never objected to the account or the balance. Defendant has not established that there's any material fact in dispute, and plaintiff is entitled to judgment. We're asking this court grant our motion for summary disposition and enter a judgment against defendant in the amount of $1,337.32 in damages plus court cost in the amount of $105.49 plus the statutory fee of $75 for a total judgment of $1,517.81, Your Honor.
All right, given that the defendant has not appeared, she did previously file a document with the court that was offered as an answer. And given further that the defendant did not respond in writing to the motion for summary disposition, did not appear on today's date to argue against the motion, and the court being otherwise advised in the premises as it relates to this matter, the court would find that the motion for summary disposition in this matter is well founded, where there does not appear to be a genuine issue of material fact, and plaintiff would seem to be entitled to judgment as a matter of law. council, I will sign the an order granting judgment on the motion for summary disposition upon its presentment. You can present that order via email if you wish to do so.
Your Honor, actually, we have a proposed order attached to the motion. So you have a copy of that order on hand. It's right at the end, past all the exhibits.
Maybe I didn't look further.
It's about 25 pages in. It's just a couple pages up from the back.
I know maybe 50 pages in. Anyway. Yeah, it was kind of thick. That's the part of the joke part. Okay. Smile a little bit. So yeah, I do see it now. Way at the end, buried under all of the other language. And I will.
That's not where I would have put it, Your Honor. Sorry about that.
That's okay. I will sign the order now, as it is consistent with the complaint in this matter. So the judgment is entered based on the motion for summary disposition having. So we'll get that out to you right away. Council.
Thank you, Your Honor. Have a great day.
Likewise.
Mhm.